For those of you who don't know me, my name is Matt Pollack. I'm a solicitor in the employment team here at Berners-Paul, and I'm joined today by my colleague Maria Misakas, who's also a solicitor in the employment team. Today's session will be an exciting topic of an introduction to settlement agreements. So, as we always do with these sessions, if I could just ask everyone to remain on mute throughout the session, that would be fantastic. If you have any questions, please just pop them into the chat box and we will come to them and answer as many as we can at the end. If we don't manage to get to any of your questions, we promise to follow up directly with you afterwards. As always, we can only give general guidance during these sessions. So if you're looking for specific legal advice, please just get in touch with me or Maria after the session or just your usual Berners-Paul contacts. And lastly, the session will be recorded. So if you have any queries about that, please just check our privacy policy on the website. We will also send you a copy of the recording of the webinar after the session today, together with some materials, some handouts that we will refer to as we go today. So, an introduction to settlement agreements. Settlement agreements have always been an effective tool in an employer's armory. They can guard against employment tribunal claims if they are done correctly. We are seeing a significant increase in the number of inquiries we get about settlement agreements, and this is both from the employers and employees. This is also a practice area that we consider to be ever evolving. So what do you actually need to know about settlement agreements? So what's the plan for today? We will look at, firstly, what is a settlement agreement? When is it appropriate to use one? What's to offer? What are the key negotiating terms? We will then look in a bit more detail into those key terms in the settlement agreement. What do we tend to see in the agreements themselves? We will discuss some tax aspects, especially post-employment notice pay, and we will finish off by discussing holding without prejudice and protected conversations. So we've got a lot to cover, an hour to go. So without any further ado, I'll hand over to Maria to get us started.
Thanks, Matt. So I'll start off, what is a settlement agreement and when is it appropriate? So first of all, ACAS Cut 3s. Before I come on to looking at the requirements for a settlement agreement and when these might be used, I'll just briefly touch on the other way of settling statutory employment claims, and that is via ACAS. So for those of you who don't know, ACAS is a publicly funded independent organisation. One of its functions is it's used to assist parties in settling employment disputes through a process known as conciliation. Generally, an employee won't be able to raise a claim in a tribunal without first contacting ACAS, which is part of the early conciliation process. And as an employer, you can ask ACAS for conciliation services if there is a dispute with an employee which is likely to rise in a claim. So in either of these circumstances, provided that both parties are open to it, ACAS can appoint a conciliator and they liaise back and forth with each of the parties with a view to facilitating a settlement. They can also provide this conciliation service to help parties settle a claim that's after it's been raised whilst tribunal proceedings are ongoing. And the form a settlement via ACAS is normally recorded as called a Cut 3 agreement, which it tends to be less extensive compared to a settlement agreement, which we'll be looking at today. So going on to the requirements for a valid settlement agreement. Where a settlement agreement is negotiated directly between the parties, there's obviously not that involvement from the ACAS conciliator, which is an additional safeguard intended to ensure that the employee understands the terms and the effect of the agreement and the particular effect it has with their ability to pursue their rights in the employment tribunal. And it's that they must receive independent legal advice on this. So the advice is usually given by a qualified lawyer, but it could also be a trade union rep or a voluntary sector advisor who is certified in doing so. And the legal advisor must have current contract of insurance or professional indemnity to cover the advice that they're giving. So it's absolutely essential that the legal advice is given, because without this, it's not worth the paper that it's written on, and is entirely void. So because of that aspect, it's actually customary for employers to offer a pay contribution towards legal fees, which this can normally range from 350 to 500 for a standard straightforward settlement agreement plus VAT. Um, so there are also certain other drafting requirements required for a settlement agreement to be valid. So one of these is the agreement must be in writing and must identify the advisor. It must specify the particular complaints or proceedings in it is the settlement, so it can't have a general waiver of all claims. It needs to set this out, and it must specifically state the conditions relating to the settlement agreement, and under the relevant statutory provisions, so these are satisfied. So moving on to when are settlement agreements used. So if you have a dispute with an employee, whether that's in relation to if it's a former employee, so if it's in relation to their dismissal or otherwise, or whilst less common, a dispute with an existing employee whose employment is to continue, you can enter into an agreement directly with them to settle a potential claim. However, in these circumstances, where there is a particular dispute to be resolved, it might make sense to use ACAS to get the assistance of that conciliation process without the need for the individual to take independent advice. So what settlement agreements are most commonly used for as a way of bringing an existing employee's employment to an end is usually on a mutually agreed basis, and settling claims whilst doing so. And there are various situations which this might be an attractive option. So one scenario that we're seeing quite a lot is in respect of redundancies. So it's quite common to see employees being paid an enhanced redundancy in recognition of their service. And in exchange for that, they sign an agreement, agreeing that they won't bring a claim. You might, for instance, want to make these offers to employees who have been provisionally selected, and if they accept that, then they can avoid concluding the remainder of the process with them, which of course saves in management time and costs. So, or if you're seeking volunteers for redundancy on enhanced terms, perhaps with a view to avoiding compulsory redundancies altogether, it could also be a sensible option for an agreement to be signed in that respect. So, of course, it isn't just redundancies that settlement agreements crop up and that are a useful tool for. It may be that you have a concern with a particular employee, whether that's disciplinary performance, capability, or just a breakdown of the relationship between colleagues. It may make more sense for parties to agree on a termination, a mutual termination, rather than go through a protracted process at the end, which might result in a claim with the individual if they were to be dismissed. Even in cases where there is little merit for a claim, it can obviously be costly to defend, and the time spent preparing for cases, witness statements, attending tribunal can divert, valuable resources away from the business. Also, it is particularly sensitive matter, or if it could be result in, reputational damage, then you'll want to avoid it reaching a public employment tribunal, because everything could be reported within the press as judgments are released. into the public on their website. So what I would just caution against, however, is the overuse of settlement agreements. So they can absolutely be used in most commercial as a sensible option, depending on the circumstance. But what can happen is a business using them as a matter of course, whatever the issue, instead of having proper processes in place to have effective management of employees. So whilst they can save in costs and be a quicker resolution, it won't necessarily be the case that they're the best option. So as settlement negotiations and discussions can be protracted, in the time it takes you to conclude those and to go through a fair process and either terminate the individual fairly with only statutory contractual entitlements, or indeed have resolved the issue, whatever that might have been in the first place. So it's not always the best option, depending on the situation and case by case basis. And you'll also have to look at and consider the confidentiality obligations within a settlement agreement, because people inevitably do talk. Packages are often offered, which might lead to an expectation of employees thinking that, if they were to raise something, that they'll then get a potential package and they'll get a payout. So equally, it can have an impact on team morale if employees are concerned that they might be the one to get, tap on the shoulder, rather than their employer working with them to resolve concerns. So, like I said, it's really just about giving some thought on each particular occasion, on whether it really is the most appropriate action in the circumstances, whether to make a settlement offer or whether it would be better to follow through, relevant processes, whatever those may be. So moving on to how much should you offer? So you've decided in this circumstance that you want to offer a settlement agreement. The next obvious thing would be how much to offer. So first of all, you would need to consider what the employee would be entitled to, and if they were terminated without a settlement agreement, so payment in lieu of notice, where they aren't serving their full notice period. You need to think about accrued but untaken holidays, so maybe they have some other contractual entitlements on termination, like bonuses or share entitlement. And in a redundancy situation, assuming the employee has 2 years service, they will of course be entitled to statutory redundancy pay. So these are things that they're entitled to on termination anyway, even if they don't sign a settlement agreement. And I suppose the next question is how much to offer as an ex gratia payment. So that's, a payment which is over and above as an incentive for the employee to sign, which waives their right to make any claims. So in assessing this, you'll want to consider what process, if you've already followed, and how long it's likely to take you to conclude that process. So if you have issues with underperforming employees, the next steps would be to address it informally. And if there's no improvement and you're keen for them to exit as soon as possible, we know that where their employees have 2 years service, then there should be a formal performance management process. And the length of time that takes will just depend upon your policies and the nature of the concern. But as you assess each of the circumstances, it could take at least 2 months to conclude. So you might want to initially offer the employee, 2 months ex gratia as an alternative to save on all that time and costs, which allows both parties to avoid the pain of going through that process and part ways amicably. And you'll also want to consider what the employee's likely prospects of success are to a claim, if they were ultimately to be terminated, and how much they would be likely to be awarded in a tribunal if they were to succeed. because this will inform the strength of your negotiating position and how much you might want to think about being prepared to offer to get the deal done and the agreement signed. So if the employee for whatever reason has potential grounds for a claim, and you should anticipate that their solicitor would probably advise them whether they should just outright reject a first proposal or come back with a counter proposal. But tactically, it would be sensible to consider what the maximum amount would be that you'd be willing to settle for, and to go in a good bit lower, so you know that you've got a bit of wiggle room from your initial offer before you leave the negotiations entirely. And that just kind of prevents you know discussions not going any further if you do have wiggle room to go about in the first place. So it can be quite a tricky balance to make, and there's no science towards it. Obviously, they're on a case by case basis and depending on what claims they might have. So it, like I said, it entirely depends on the individual. You could get someone, for instance, who, despite the advice they get from their solicitor, has totally unrealistic expectations, or even just would rather have their day in court, regardless of what you're prepared to offer. So you should always have a plan in place for the next step in the event that the employee doesn't want to accept that. So going back, so you've decided that you're going to offer a settlement agreement and how much you're going to offer. You'll then want to draft the settlement agreement. So I'm now going to pass you on to Matt, and he will discuss the key terms in the drafting of a settlement agreement.
Thanks very much, Maria. So keep in mind that every settlement agreement will be different. This will depend on the reason for entering into a settlement agreement, discussion in the first place, the potential claims that the employee might have. However, typically a settlement agreement will include what's been agreed between the parties in relation to salary, notice pay, holiday pay, so anything accrued but untaken at the date of termination, compensation payments, bonus entitlements, shares, and so on and so on. So parties can agree what will happen in relation to many things. That includes company property, but also post-termination obligations. So that's your confidentiality, IP, non-disparaging comments, restrictive covenants, and so on. One of the real benefits of a settlement agreement is that, well, it's exactly that. It's an agreement. You can agree what will happen in relation to so many things, including, importantly, that the employee will agree not to bring a claim against the company. So some of the things to think about when drafting a settlement agreement are set out in the checklist we've got, and we will be sending this to you after the session. The checklist is quite comprehensive, and it's useful to remind you what to include in the agreement, what to think about, but it's also useful to complete and then send to us if you're asking us to draft the agreement for you. So like I said, the checklist is very comprehensive. I think it has about 40 questions, but I'll deal with just a few key points from that checklist. So first of all, it may seem obvious, but the first thing you want to think about is the identity of the employing entity. So effectively, who is the employer? This isn't always as straightforward as it seems, especially in group companies. You should check the contract of employment. There may be cases where you want to include more than one employing entity. So for example, in a case where there's a two-pay transfer and you may have a tripartite agreement. So an agreement where you have three parties to the settlement agreement. That's the employee, the transferor, and the transferee. When drafting a settlement agreement, it's important to look at the employee's contract of employment, especially check if there is a pile-on clause, so that's the payment in lieu of notice clause, or not. If there is, to check what it says. This is important because if you are paying in lieu of notice under a settlement agreement, which means that the employee is not working their entire notice period up to the termination date, then you'll need to check if the pile-on payment should be salary only or salary and benefits. Also, if you're paying in lieu of notice without a pile-on clause in the contract, which means that you don't actually have the contractual right to do so, you're technically in breach of contract. So that means other terms in the contract can fall away, which could relate to restrictive covenants, IP, and other things you'd want to retain. Of course, one of the main considerations is that you are going to pay certain sums to the employee. What are those sums and when you'll pay them? Has the employee received normal salary and benefits up to and including the termination date? Is there perhaps a period of suspension? This is all something you want to deal with in the agreement. You want to narrate what happens exactly, what is going to happen, what has already happened, when is or when was the termination date. We do have agreements when employment already terminated, so it's all in the past, but most often we have a termination date in the future. So this will also um, affect how we approach things. Next question, will the employee work some or all of their notice periods? Will there be a period of garden leave perhaps? And if so, uh, check the contract of employment. Is there actually a garden leave clause in the contract? If not, we'll put this into the agreement. So all of this will have to be considered and ideally set out in the terms of the settlement agreement. Of course, you can enter into a settlement agreement when, like I said, employment is continuing, but in vast majority of cases, employment will be ending or has already ended. Um, Next point to keep in mind, is the employee due accrued by taken holidays? Have they been paid all holidays due already? Either way, you should explain this in the agreement. It may also be that the employee owes the employer holiday pay. So have a think about if you will want to recover these sums or not. If they're being placed on garden leave, you can require them perhaps to take all the holidays up until termination date. So just another point to keep in mind. Um, are there any other payments due? Bonuses, commissions, statutory redundancy pay, different sorts of bonuses, share arrangements. And then you'll want to think about how much, like Maria said, the settlement payment will be. Um, you could say this is the sum that the employee agrees to accept in return for waiving the claims. And if the other payments are all payments that the employee would otherwise be entitled to anyways, if the employee doesn't sign the agreement, there's just no incentive for them to do so. So it's important to set these payments out for a few reasons. One reason is that the employee's solicitor will quite often want to see in detail those sums to work out if the employee is being paid what they're entitled to be paid. But it also helps to work out what payments are taxable, what payments are not. So it's important to break it down, spell it out, put as much detail as you can, rather than to pay just one lump sum. And the same will apply to actually paying those sums. You'll want to itemize these on a payslip. And then also clearly set out when the payments will be made. So typically what we see payment terms will be 14, 21, 28 days from the date of termination or the signing date. We also see employers put in a reference to the next payroll run, which is also completely fine. So think about how quickly you can actually make those payments. And then the quicker you can pay, the more attractive the settlement agreement will be to the employee if in their mind they have it that they will have those sums in their bank accounts in the next 2, 3 weeks. That's more attractive than 2 months away. So what about benefits? Quite often we will make it clear that benefits will cease on the termination date. This is just the simplest way of dealing with it. It avoids having to consider any tax implications of continuing benefits beyond the termination date. Um, However, there may be cases where benefits are provided beyond the termination date. So one example of that would be you may be negotiating a settlement agreement with an employee who has health insurance and is using that insurance for ongoing treatment. It can be for themselves, could be for a member of the family that's also covered under the plan. Um, so continuing that cover beyond termination date might be a deal breaker for that employee. So you'd want to think carefully about the relevant drafting in that clause and take tax advice. Um, Agreeing to an extension can also be an incentive for the employee to agree to sign the agreement. Next, think about whether you will be providing any outplacement support. So this may be something we see more of as the number of employers negotiating redundancy related settlement agreement increases. So provision of outplacement counseling will often be quite inexpensive for the employer. Its value to the employee will often depend upon what juncture in their career they're at, and the level of skills, experience. So think of it like that. Someone who is confident about obtaining new employment, they've got lots of skills, lots of experience, and they have good existing network of contacts. They may not value this benefit and may seek an enhanced termination payment instead of the provision of this benefit. But on the other hand, someone without that much experience or good network, they might consider this benefit to be much more beneficial to them. The waiver of claims, obviously, super important part of the settlement agreement. The agreement should be specific about which claims the employee is waiving. So you should give thought to the particular claims that the employee may have. So for example, if you are in a redundancy situation, you will want to ensure that you waive claims for unfair dismissal, wrongful dismissal, unlawful deduction from wages, redundancy payments, and so on. I will always advise you on that. You might also want to waive certain discrimination claims. Like I said, every settlement agreement will be different, so do spend some time thinking about the specific circumstances in front of you that apply to your case. Now, there are some claims that cannot be waived. So you'll often see these claims explicitly carved out. So for example, claims to enforce the terms of the settlement agreement itself. Could be claims relating to accrued pension rights and also personal injury, or at least personal injury that the employee is not aware of or could not reasonably be expected to be aware of at the termination date. Um, it's also important to ensure that if you're waiving claims under particular pieces of legislation, that the agreement states that the special conditions relating to settlement agreements in those pieces of legislation have been met. And this is often done in a separate clause. Again, we would always advise you on that, but this is why we need to have all the details about the situations that we can be informed and advise you accordingly. It's also worth just mentioning that you cannot contract out of the right to statutory maternity pay, statutory adoption pay, or shared parental pay. So that's just something to keep in mind. Another important one is claims for failure to inform and consult with appropriate representatives on collective redundancies under trade union legislation, and also some similar claims under the 2-pay regulations. As Maria said, ACAS can conciliate in relation to these certain claims, and these claims would be included. So Maria mentioned some of the differences between a COD3 and a settlement agreement earlier. So this is the one time you might consider using ACAS and COD3 instead of your normal settlement agreement. While you can't waive these claims, you can still draft the settlement agreement such that if such a claim is brought, then the employee has to pay back some or all the settlement agreements. So even though they're not waiving the claims, it's still a disincentive for them to do so. It's a deterrent. It's also common practice for warranties from the employee to be included in a settlement agreement. So that's basically just a written guarantee. The employee confirms something to be true or something that they will do. So these will usually cover the return of the company property, um, things relating to confidential information, documents relating to the business. Just on company property, you will want to consider what property um, specifically the employee has and when and how it should be returned to the company. So I think company cars, laptops, phones, other expensive items. So it's crucial that the agreement is clear on that. Um, you might want to include confirmation that the employee has not received an offer of employment before entering into a settlement agreement, since this may affect the amount of compensation you as employer are willing to pay. Um, Confirmation that the employee has not committed any repudiatory breaches of contract of employment, which would have entitled the employer to terminate their employment without notice, or payment in lieu of notice should be included. So that's your, gross misconduct that you may not be aware of. As Maria mentioned, the employee must take their own independent legal advice before they can validly sign the agreement. Without this, the waiver of claims will not be valid. Um, so, what about reaffirmation letter or double signing, as it's also referred to? So, this is something we advise clients to consider if there's a lengthy period between the date of signing the agreement and the actual termination date. So, say the employee signs the settlement agreement in January, but then they'll work their entire notice period, which happens to be 6 months. So, that's a long time. A lot can happen during that time. One solution is for the employee is to repeat the waiver of claims together with any warranties that the employee is not aware of any claims. Once employment has terminated, or at least closer to the actual termination date, and this can be done through a reaffirmation letter. Um, the general rule of thumb is that if there's a gap of at least 1 month between the date of signing of the agreement and the actual termination date, we will advise for a reaffirmation to be included. But ultimately, it's a business decision. Agreed references are also commonly included as a schedule to a settlement agreement. And the benefit of that is that both parties know exactly what will be said if a reference request is made. So references tend to be just basic factual references only these days. So something along the lines of Joe Bloggs was employed by company A from start date to end date. You can also mention their position or most recent position. If they were employed for a long period of time, there's some changes during that period. If you're providing a reference, especially if it's more detailed, you should take reasonable care to ensure that the information is true, accurate, and fair. Does not give any misleading impression, especially if some time has passed since the signing of the agreement and agreeing the terms of reference. And yeah, I'll now pass on back to Maria, who will take us through quite a few things. So that's confidentiality considerations, differences between Scots and English law, and also some interesting tax considerations. You're on mute, Maria.
Apologies. There we go. Can you hear me now? Fab. Thanks, Matt. So just on confidentiality, use of NDAs, non-disclosure agreements. So quite a big topic, could be a topic on its own, but I'll try and give a brief summary. So there's been quite a lot of attention on the use of NDAs. Sorry, just something on my screen. There we go. Yeah, there's been quite a lot of attention on the use of NDAs. So it's really important for employers to, understand what they can and they cannot do, when it comes to confidentiality clauses. So it's normally in both parties' interest for the terms of the settlement agreements to remain confidential, and an express term to that effect is often included. However, public scrutiny of confidentiality clauses has increased, so employers are advised to give, real thought as to what's exactly required on a case-by-case basis. Just as a bit of background, in 2023, the Solicitors Regulating Authority issued a report on compliance for practitioners, with a warning notice on using NDAs. And one of the conclusions on that was that, practitioners should proactively consider whether the use of an NDA is really appropriate or necessary in each case, taking into account the facts and the individual involved. So subsequently from that, the SRA updated their warning notice, which stated in the 6th of August 2024 that NDAs should not be used routinely. And from the outset, firms and clients like yourselves should consider carefully whether an NDA is necessary And like I said before, given the specific circumstances of each case. So those dealing with NDAs shouldn't become overly reliant on specific templates. Um, and these templates should always be tailored to the individual. That said, most employers do continue to use the confidentiality clause. Typically, previously, the agreement would only permit the employee to disclose its terms in limited situations and sometimes circumstance, for example, to only immediate family members, their legal advisor, or professional advisors. So, if you are drafting a settlement agreement, always give thought to the confidentiality wording. And there are various guidance notes about this from ACAS, the Law Society of Scotland, the Law Society of England and Wales, and the Law Society practice notes also recommend that exceptions and restrictions on any broad duty of confidentiality are expressed in clear English. So these may include that, making a protected disclosure which results in blowing the whistle, reporting misconduct or a serious breach of regulatory requirements to the appropriate regulator, reporting a particular offence to the police, or cooperating with a criminal investigation, referring personal or other tax-related matters to the tax authorities, being permitted to disclose in the context of seeking tax, medical, or professional advice, and disclosing whether required by law or regulatory obligation, or where or when the employee is representing themselves in any investigation or proceedings brought by a regulator or professional body in relation to matters arising from their employment. And ACAS also include guidance where non-disclosure agreements should not be used. And these include the following examples: if before seeing if another solution can be used instead, when confidentiality is not needed, to avoid addressing disputes or problems, to mislead someone if it could cause serious moral or ethical issues, if it could cause any other negative outcomes or effects, and if it's a matter of routine. So moving on to the differences between Scotland and England. So let me just change my slide. Apologies, cursor is flying about 2 seconds. Okay, I'll just leave that. So the differences between Scotland and England and Wales. So we regularly draft agreements that apply both sides of the border, and quite often we're asked to kilt a settlement agreement, and that means it ensures with Scots law, or if it was in the relation to England Wales, it refers to that jurisdiction. So employment law, I'm sure many of you know, is UK wide, but there are differences in relation to contract law. So we need to think about these aspects and apply those. So one of the important contract law differences is the concept of consideration. So as a matter of contract law, consideration is not required to form a binding agreement, binding contract, in Scotland, and it's not uncommon for an employee to sign a settlement agreement where there is no consideration allocated. However, consideration, which is typically a sum of money, is required to create a binding contract in England and Wales. And it's not uncommon in settlement agreements to see separate considerations being granted where the employee is entering into fresh post-termination restrictions. So while in Scotland, this is not required as a matter of contract law, there could be tax implications on this if a specific sum is not carved out in respect of these. And actually, in light of tribunal, which was in relation to tax, we are advising clients to include a separate payment for post-termination undertakings such as confidentiality, non-disparaging terms or restrictive undertakings. And that's whether the agreement is governed by Scots law or under the law of England and Wales. And another difference is in relation to third party rights. So in England and Wales, the settlement agreements may contain a third party rights clause narrating whether third party rights under the Contract Rights of Third Parties Act 1999 apply in respect of the agreement. So the 1999 Act doesn't apply in Scotland, and instead it is the Contracts Third Party Rights Scotland Act 2017 which is applied, which may apply to create an enforceable right in favour of a third party. So furthermore, in Scotland, the signatures of the employer and the employee are often witnessed, although it's not strictly necessary under the Requirements Writing Scotland Act. This is generally done because it makes the agreement self-proving, and this means it is presumed by the court to have been validly signed by the parties, and therefore if it was ever challenged, it would make that challenge quite difficult. In addition to this, to comply with Section 7 of the Requirements Writing Scotland Act, the signature of at least one party to the agreement must be on the last page of the document. So the last page for the purpose excludes, like schedules. So if you're ever drafting a Scottish agreement, it's worth bearing that in mind. And there are also key differences in how schedules are dealt with. So in England and Wales, the schedules to the agreement are found within the agreement itself before the signing page. Whereas in Scotland, the schedules are annexed at the back of the agreement after the signing page. So in order to comply with the Requirements Writing Scotland Act, a schedule to the document must be referred to the body in the body of the document, and it should be identified on the face as being the schedule referred to in the document. So each page of the schedule should therefore, be marked clear that it belongs to the main agreement. And electronic signature is also becoming increasingly common now for settlement agreements. So that's one of the good things that came out of COVID, and obviously it's stuck around. So it makes signing a lot easier. There are certain rules about how you do that, and there are differences in Scottish law and the law of England and Wales. So now that we've covered what to include in a settlement agreement and what to think about the draft when you're drafting a settlement agreement, it's also important to think about the tax and the tax treatment in terms of the termination payments. So now that I've managed to get my cursor there, perfect. So I'll start this section just by saying that I'm definitely not a tax expert. We quite often involve our tax team if the tax position isn't straightforward. So I will keep this quite high level. So why do employers need to know about the taxation of settlement payments? So taxation can be sometimes a bit of an afterthought. Once the termination payment's been made and agreed, there are important reasons as to why employers should consider the tax implications early on when the termination payment is being negotiated. So if an employer fails to deduct, tax, national insurance contributions from a termination payment, it is the employer who is liable. And in addition to any unpaid tax or national insurance contributions, HMRC can also recover interest and penalties from the employer. Although the tax and employee national insurance contributions element could be recovered from the employee under the settlement agreement, the penalties and the interest are generally not, as it's likely that these have risen from the employer's fault or their delay. So in addition to tax and employee national insurance contributions, employers may also have to pay employer national insurance contributions on certain payments, and this can significantly add to the cost of the settlement agreement. Therefore, both parties will want the termination payment to be legitimately structured in a way that it minimises that tax liability for both parties, to ensure there's no issues in the future. So, how much of the payment is taxable? The tax treatment of a termination payment will depend on the nature and the amount of that payment. Therefore, it's important to ascertain why the payment is being made and all of the background facts. So, payments typically fall into three categories. So, A, payments that are treated as earnings and are taxable in full, subject to income tax and employer national insurance contributions. So, that's typically your salary payments, contractual bonus, commission, or contractual payment in lieu of notice payments. So, it will also include amounts payable for entering into restrictive covenants and your post-employment notice pay, known as PEMP. And then B, payments that are treated as a termination payment benefiting from the tax exemption on the first 30,000. So with any excess subject to tax and employer national insurance contributions, not employee national insurance contributions. So I'm sure many, if not all of you, will be familiar of the concept of the £30,000 tax-free exemption, but we do see clients trip up on these sort of things. So do be cautious that not everything is tax-free up to 30,000. And then C, payments that are fully exempt from tax. This includes payments on accidental death payments solely on the account of injury or disability. And also in this category is employer contributions to registered pension schemes. So these can be made tax-free without using any of that 30,000 exemption amount, but also care does need to be taken in relation to the PEMP rules. As such payments as these require the pile-on to be paid to the employee subject to tax and national insurance contributions in full. So there are some tax-free benefits that can be provided to employees. Outplace counselling and retraining can be available tax-free if the payment is being directly made to the provider of the service by the employer, and the legal costs that are paid to the employee's lawyer in connection with the settlement agreement can also be tax-free. So just circling back to the PEMP, the post-employment notice pay. This is something that quite often comes up and that we see with that employers sometimes miss, or they've not properly understood how it should be calculated. And consequently, tax and national insurance contributions as a general rule are payable and at least part of the settlement package where an employee has not worked the full notice pay, irrespective of whether there is a contractual payment in lieu of notice clause there. So the PEMP amount is calculated via two methods. So one of the methods is that the complete months method, where the employee is paid monthly and their notice period is expressed in calendar months. Or the second is an alternative days method, where the employee is not paid monthly, but say they're paid weekly, or their notice is not expressed in months and it's expressed in weeks. So I'm not going to go into the further details of that, but both of these obviously require employers to ascertain the basic pay in which employees were entitled to in their full pay period before notice was given, or at the point the employment contract was terminated. So essentially, once you've figured out your PEMP figure, you'll know the amount that is then therefore taxable. And I will now move you back to Matt.
Thanks very much. I'm conscious of time, so we'll hopefully keep it short and sweet. So on the topic of protected conversation, so as Maria mentioned before, rather than go through capability, redundancy, or disciplinary process with the risk of subsequent litigation and in some cases negative publicity, It's often seen as commercially beneficial to just approach the employee to have an exit discussion with them. And there is the long established principle of law called without prejudice principle, which essentially means that generally speaking, this prevents statements made in a genuine attempt to settle an existing dispute from being put before the court or tribunal as evidence. But this can present real difficulties in the employment context when these exit discussions are taking place long before anything as concrete as a dispute has arisen. And this may make employers, wary of initial conversations with employees about possible exit from the business, in case the employee then relies on those discussions to claim that the employer had already made up their mind, and so any subsequent formal processes were predetermined, such as selection for redundancy or capability process. So the dismissal would then be unfair. So in response to this specific problem, back in 2013, the government introduced the concept of so-called protected conversations. You'll also see people refer to them as pre-termination negotiations. So these operate alongside the without prejudice rule. So this statutory framework enables employers, businesses to have off-the-record conversations about terminating an employment relationship without the fear that these will be disclosed in ordinary unfair dismissal proceedings. But this is the key. It applies to ordinary unfair dismissal proceedings only. So this means that, and this is assuming that the without prejudice rule doesn't apply, there's no dispute, the offer and discussions can still be used and relied upon by the employee in tribunal to support any other claim. So that includes discrimination, automatically unfair dismissal, unlawful detriment claim, breach of contract. So the application is quite limited. And even in an ordinary unfair dismissal context, the conversation will not be protected if it is found that there's been some improper behavior on the part of the business. So this includes putting undue pressure on the employee to accept the offer, instances of bullying, but also, for example, if it is found that the employee was not given appropriate time to consider the offer, or was advised before any disciplinary process has begun that if the offer is not accepted, then they will be dismissed. That's also undue pressure. And because of the significant limitations on this framework, we would generally advise that you approach those discussions on the assumption that anything you say will be admissible. So just don't say anything that you wouldn't want later to come out as evidence in tribunal. And so, what steps should you take before having that conversation? As I say, in most cases, protected conversation is being held as a precursor to a process, which may follow if agreement cannot be reached. So, in these cases, it can be helpful to initiate this formal open process first before holding a separate protected conversation. And the reason for that is if the offer is made entirely out of the blue, an employee might be less inclined to accept it. It can also damage the relationship between the business and the employee going forward, or make any subsequent process loop predetermined if agreement is not reached. So to take an example of a redundancy situation, if you were to approach one individual in a pool before doing the scoring exercise, they will probably feel that they were singled out and that any process to follow is just a sham. So, but on the other hand, if you have pooled and scored employees and that individual you are approaching is the one who has been provisionally scored the lowest, well, whilst the scores are still subject to consultation, they will generally be more likely to accept an offer from the business. And when you do meet the employee to have that sort of discussion, what do you need to keep in mind? Well, you should make sure that you're going into the meeting knowing exactly what you're going to say. So it can be helpful to have some bullet point notes with the things you want to say and how you are going to approach the conversation. We would also recommend that at the outset of the meeting, you explain to the employee that you are going to um, have this protected without prejudice conversation with them. meaning that it must be kept confidential. It would be inadmissible if any tribunal proceedings were to occur, and checking that they're actually happy to have this off the record type of conversation. If they're not, you don't continue. But if they are happy to proceed, you should then set out clearly to the employee the background that has led to discussions, but in a neutral manner. So, in a performance situation, it may be explaining the performance concerns that you previously had and which have been highlighted to the employee, the support which was provided to them up to that date, the process already followed, and ideally the fact that it's been discussed with them and there has been, as of yet, no or little improvement. So this is effectively what you consider to be the next reasonable step. You'll then want to ensure that the employee is clear on the risks of remaining in employment so that they are incentivized to accept the offer. So it might be that a formal performance management process is to follow, and then ultimately that the potential outcome of that full process might be dismissal, which means they'll only be entitled to statutory and contractual entitlements. You should also be clear about what the terms on offer are, and generally you'll want to present these as being offered as an alternative to the formal process rather than as an alternative to dismissal itself, because then you would essentially be acknowledging that any outcome would be predetermined. Um, Employees can respond positively when an offer is presented as something which gives them an element of control over the circumstances as well. And what you want to get across to the individual is that the conversation, just having the conversation, is entirely up to the employee. If they would rather proceed with the formal process, there's no pressure on them to accept the offer, and they can, you can just leave the conversation and continue with the formal process. After the session, we will be sending you our top tips on those conversations, as well as the ACAS code of practice. We'll also provide you with a template letter that can be issued to the employee following the protected conversation, just setting out the key terms of the offer. You'll see that the letter is marked as confidential and subject to the protected conversation statutory framework, which is something we always recommend. It's also marked subject to contract. So the intention of the subject to contract wording is just to ensure that negotiations don't give rise to any binding agreement until the final terms are agreed and the contract is actually signed. If employees are not given sufficient time to consider the offer, this might amount to undue pressure. So the ACAS code suggests, as a rule, the minimum period of 10 days to consider the proposed formal written terms. So if you want things concluded quickly, it can be a good idea to just have the settlement agreement drafted in advance of the meeting so that you can actually hand it to the employee along with the letter so they can take it away, go and take legal advice on the whole package, and then have this clear timeline of 10 days to get back to you. Um, that's all from me. I'm just going to hand back to Maria. I'm conscious we have 1 minute before we need to finish up.
Yeah, so if anyone's got any questions before we finish up, we'll happily take those if you want to unmute yourself. Just check there is.
Yeah, I think there's one question from Julie in the chat. Once an employee has engaged legal support on their settlement agreement, can and should the employer still continue to talk directly with them about the terms negotiation? So I would say the best practice would be to go through the solicitor appointed. So what happens usually when an individual approaches us and we are instructed, we will be the sort of intermediary, the point of contact between the individual as our client and the business. So we will pass the communication between the parties, but you can just follow the employee's direction. If they are very clear and they communicate to you that they want all correspondence go through them directly, I suppose it would be a bit unreasonable not to comply with that. But best practice, I would say, just to check with them what their preference is. If you have the details of the solicitor, I would probably err on the side of caution and just contact the solicitor. But yeah, best to always just ask the question. I don't know, Maria, if you have a different view.
No, I agree. Agree with yourself. Is there any other questions? Sorry, I can't see the chat box. For some reason.
Nothing more in the chat.
Well,
So,
before if there is any more questions, then feel free to contact myself or Matt. Like we said, we will send over the recording and the several attachments probably tomorrow. So if there's anything that you think, from now, just give us a shout. Thanks again for joining, and really hope you found this session useful, and hopefully we'll see you at one of the next sessions.